All right, good morning. I have the pleasure of introducing Chairman Doty. Jim is the chairman of the Public Accounting Oversight Board. He was actually appointed to this position by the Securities and Exchange Commission in January of 2011. Prior to that, he occupied the position of General Counsel at the SEC. And many of you understand how the SEC operates in terms of the different divisions, but really the power behind the throne at the SEC is the General Counsel. General Counsel touches everything at the SEC, from enforcement to all aspects of rulemaking, and is an incredibly important position. And Jim handled that job admirably over the time he was there, and I grew to really respect the GCs during my time at the Commission. Prior to that, and really following his service at the SEC, he was a partner at Baker Botts, where he practiced security and corporate law. He was an active counselor, board of directors, and audit committees on regulatory and compliance matters, including things that arose under Sarbanes-Oxley. Not going to spend a lot more time. I got to know Jim personally while I was at the Commission. We spent some time talking about incorporating more economic analysis into rulemakings, and I found Jim to be a real gentleman and a scholar. So without that, Jim, glad to have you here.
Well, thank you. I want to thank Peter Easton and Craig Lewis for inviting me to speak to you and all the people at CARE who've made this event possible. It's a real honor for me, as Craig says, a kind of recovering corporate lawyer and historian Mckesson, to be among real intellectuals, scholars, and people who are on the edge of the thinking in their profession. So it's a treat. As Luigi did last night, I would like to begin by saying that the views I express are my own. They should not be attributed to the Pcaob as a whole or any other members of the staff. I'm honored to be with you today, especially since I'm not an economist or an accountant, and I look forward to discussing first evidence-based policy. I'm an enthusiastic proponent of evidence-based policy making, particularly in the area of the audit. We will continue to do everything I can to establish a solid and lasting footing for economic analysis at the Pcaob, and I hope my remarks tend to confirm that. I've been asked to speak about the auditor's role in the detection of fraud, and I'll start with some history. Then I will get into work the Pcaob is doing to apply empirical tools and analysis in order that we might understand better why auditors may fail to identify or react appropriately to the signs of fraud. We also want to use these tools to come up with some cost-effective ways to motivate auditors to identify fraud and respond appropriately to the red flags. So, here goes. Some history by historian Mckesson. The mandatory audit originates as an economic response, I point out, to crisis. The Securities Act of 1933 imposed the requirement in the context of the worst economic depression in the nation's history. The Securities Act was enacted, as we all know, to restore investor confidence in the wake of the crash of 1929. It promoted capital formation and economic growth principally by coaxing people back into our securities markets. It did this by regulating the offer and sale of securities to ensure that buyers of securities receive complete and accurate information, including audited financial statements, before they invest. Inoculated at the SEC as I have been, this is my view of the history of the 33 Act. The audit is the linchpin to give shareholders of public companies confidence they can rely on those financial statements for deciding whether and in which companies to invest and at what price. It's meant to provide reasonable assurance that the financial statements examined are fairly presented in conformity with an applicable accounting framework. Thus, investors and potential investors can be assured that the statements are free of material misstatement, whether due to error or fraud. Auditors are intended to be the eyes through which investors look for the truth about a company's financial condition and results. But this vision was only imperfectly realized. While the Securities Act mandated audits, less attention was paid to addressing the inherent and acknowledged challenges in expecting third-party auditors to police their own clients. the auditor's fairly attenuated connection to investors competes with the magnetic pull toward the client, both through the engagement contract as well as through natural human interactions with the audit. This magnetic pull, if you will, has interfered with the audit's ability to achieve the full extent of the Act's goals from the earliest days after enactment. Again, a little history. And I'm interested in this history in a certain pattern, the way in which the auditing standards and the auditor's willingness to confront fraud sort of slowly creeps up on and approaches the facts of the audit, but never wanting to get as close as it might. The first significant test of auditors' zeal to root out fraud was the Mckesson-Robbins scandal, discovered in 1938. There, corporate insiders generated fake sales documentation and paid cash commissions for those sales to a shell company under their control. The scheme resulted in $20 million of fake assets on the company's audited financial statements. The auditors defended their failure to have discovered the fraud by saying, I quote, "It has not been a general practice, or at least not generally understood, as a regular part of the auditor's duty to make tests of inventory." Well, why not, one might ask, and in fact, the newly formed SEC did ask just that. Shortly thereafter, the predecessor of the American Institute of CPAs made it a general practice by providing so in its first statement on auditing procedure. The first standard also clarified the profession's position on the auditor's role in detecting fraud and its limits. And I want to quote this again. Notice how they get close, but not too close to the risk. In carrying out his work, the independent certified public accountant must always be on his guard against collusive fraud and be alert in detecting any sign of such collusion. However, on the basis of this examination, of his examination, certain gender bias here, on the basis of his examination by tests and checks, he relies upon the integrity of the client's organization unless circumstances are such as to arouse suspicion, in which case he must extend his procedures to determine whether or not such suspicions are justified. Later, after resolution of the SEC's public proceeding in the Mckesson fraud, the profession adopted more statements on auditing procedure, in particular on the form of the accountant's certificate, to prevent it from being misleading. Notwithstanding these advances, a spate of greater frauds unfolded in the 1960s. Westech, National Student Marketing, Equity Funding, other prominent companies. The profession faced a second major crisis in confidence. To address the crisis, the profession established the Cohen Commission, which recommended several changes in practices. The AICPA took this up as standards in '77, including the Statement on Auditing Standards number 16 on fraud. SAS 16 required the auditor to plan the audit to, quote, search for errors or irregularities that would have a material effect on the financial statements, but it provided little in the way of mandatory procedures focused on fraud. Rather, it stated that the auditor's search for material errors or irregularities ordinarily is accomplished by the performance of those auditing procedures that, in his judgment, are appropriate in the circumstances to form an opinion on the financial statements. As the profession grappled with how to articulate standards for its members, failing to blow the whistle on the major frauds that had come to light, nevertheless landed the auditors in legal, regulatory, even criminal proceedings for failure to conduct the audit with due care and professional skepticism. The risk is overpowering here. It's overbearing. In each of these cases, the public was left to wonder why the auditor failed to exercise due care, especially given the risks of penalties, both monetary and reputational. How do the incentives to keep the client interact with these risks begins to be noticed. In their time, these referenced collapses were considered the frauds of the century. They triggered seismic upheavals in every aspect of the accounting institution. Nearly every major firm touched one or more of these cases. The profession lost its authority to set accounting standards, replaced by a new Financial Accounting Standards Board. It was forced to make significant commitments to establish new institutions to set auditing standards, conduct peer reviews, and impose a more rigorous disciplinary regime. Yet less than a decade later, new scandals emerged. ZZ Best stood out, first for how brazenly the managers duped the company's auditors. Then, when the auditors received a tip about the fraud, they quietly resigned, claiming later that California law forbade outside auditors from disclosure without permission of the client or a subpoena. There were also the savings and loan associations, more lawsuits, more congressional hearings, more bad press. Per an auditor for Lincoln Savings and Loan, the alleged fraudulent transactions were complex. Judgmental decisions were sometimes necessary to determine when accounting rules applied and which accounting rules applied and how to apply them. An accounting firm hired by the government to investigate Lincoln's financial statements cut through this complexity and responded that the transactions analyzed were accounting-driven deals created for the appearance of profits. It concluded that Lincoln was manufacturing profits by giving its money away. On the face of it, the government's auditors was hired to search for errors or irregularities that would have had a material effect on the financial statements required by SAS 16. Weren't Lincoln's auditors also hired to search for errors or irregularities? Why was the government's accounting firm able and willing to simplify nomenclature and cut through the complexity and report the fraud, while the company's accountant was not? These questions led to a new suite of auditing standards introduced in 1988 to address the expectations gap. They included a new requirement that the auditor disclose in an audit report when there's substantial doubt that the company will continue as a going concern and report illegal acts it becomes aware of to the company's audit committee. This was a precursor of a bill sponsored by then Congressman Wyden, which was eventually acted as Section 10 Cap A of the Securities Litigation Reform Act of 1995 and remains here today as law. The expectations gap standard also replaced SAS 16 with SAS 53, which seemed in a modest way to go further. It provided that the auditor should assess the risk that errors and irregularities may cause the financial statements to contain a material misstatement. Based on that assessment, the auditor should design the audit to provide reasonable assurance of detecting errors and irregularities that are material to the financial statements. But it also volunteered, and this is also characteristic of the standard setting process. It undercuts, there's another current here. It volunteered that, quote, because of the characteristics of irregularities, particularly those involving forgery and collusion, a properly designed and executed audit may not detect a material irregularity. Hedging bet, a little bit of a hedge. More scandals followed: Waste Management, Sunbeam, Cendant, Livent, Just for Feet. In 1997, SAS 82 replaced SAS 53, this time adding requirements to consider specific fraud risks when assessing the risk of fraud. Then Enron broke in 2001, WorldCom in 2002, bookending dozens of revelations in the months between Congress enacted Sarbanes-Oxley. But before the Pcaob opened its doors, the profession adopted one last 84-page standard on fraud. SAS 99, on consideration of fraud in a financial statement audit, provided significantly more robust discussion of procedures the auditor should perform to root out fraud. It became part of the Pcaob's body of interim standards, and over time, it has been updated further to align with improvements in other standards. Now, I don't march through this depressing history to prove that standards don't work, no matter how principles-based or how detailed and prescriptive the procedures. To the contrary, I think when written well and enforced, I believe they do make a difference. But it's not the whole story, and we need to look back on why it is that the profession, or how it is that the profession continually stops short of taking on themselves the risk of saying in their audit report, we scope our audit to look for areas for error, whether caused by, looking for material misstatements, whether caused by error or by fraud. In the Pcaob's 14 years of inspecting the audits of public companies, inspectors have found many examples of high-quality work, including evidence of auditors pushing back on clients and demanding they change their accounting, or approve their internal controls over the production of financial reports. They are the unsung heroes who avert scandals that don't happen. I've also noted, especially recently, a sincere tone of commitment to quality from the leaders of many of the firms that are regularly inspected. A trend by leaders in the profession, forward thinkers, to think that perhaps we should not be so concerned and so focused on limiting risk, that we're about risk, the public expects us to confront risk, and that perhaps providing a greater insight, a greater confidence in the value of the audit by the public warrants us taking on a little more risk. Well, have our inspections had a role in driving improvements and buttressing investor confidence? The evidence is coming in, and the answer is a resounding yes. Our inspections have revealed heterogeneity, inconsistency, and quality, and have called out these instances. Over the years, and continuing to this day, inspectors have found and reported numerous instances in which they believe, based on reviewing the engagement team's work, that the firm's audit report should not have been issued. That's the Part 1 finding. These instances would include audits of some of the largest companies in the world, as well as mid-size and smaller companies. This persistence of heterogeneity and quality, I believe, demonstrates why we must enter into another area, enlist deeper analysis, use economic tools. You heard from Luigi last night on many of the initiatives of our Center for Economic Analysis. We've made significant strides towards standing up a core of external and staff economists who are already producing a significant, insightful, and growing corpus of research to help us answer some of these questions behind the history that we've just discussed. The center is now comprised of 11 full-time PhD economists, plus 3 economic fellows, 2 inspections fellows on an internal rotation, and a handful of research assistants. The center fosters economic research on topics of fundamental importance to audit oversight and investor protection, prepares economic analyses to inform standard setting and other PCAOB rulemaking, and it develops empirical tools that enhance the effectiveness of PCAOB programs. To my mind, the research function is critical to understanding how to improve our oversight. Since its formation, the PCAOB has collected a significant amount of data. The Center's research fellows and staff probe this data to challenge untested assumptions, identify gaps in our knowledge, and provide critical evidence and insight to inform our oversight choices. The Center's research is subjected to academic peer review, allowing for robust, credible, independent analysis. Our working papers can be found on the Center's page on the PCAOB website. It's modeled off the vibrant working paper series of the SEC's Division of Economic and Risk Analysis. And I can't say enough to thank Craig Lewis and the SEC for what they've done to help us get this vital research effort going. In less than 2 years, at times in collaboration with our staff, economists, or outside academics, our fellows have developed 6 working papers on topics of direct relevance to the PCAOB's investor protection mission. The results of these papers challenge our thinking and provide facts that sometimes run contrary to established views. To give you a sense of the questions we're exploring and answering, one paper examines the effects of PCAOB oversight on confidence in financial reporting, which gets right to the heart of the underlying purpose of the mandatory audit. The results provide evidence on the benefits of PCAOB inspections. How? Well, for the first time, we can measure an increase in market responses to reported earnings and hence credibility based on our inspections, confirming the impact of inspections on investor perceptions in the value of the audit. It's a timed research. What does the market do with respect to various sensitively established time intervals relating to the publication of a report or the entry of a firm into our inspections system? Another paper examines the impact of PCAOB inspections on auditors and public companies. These results give us some nuanced insights that we would not have known without the use of empirical analysis. We wouldn't have known it. Impression, anecdote, our gut sense, our feeling of what is true now gets tested. These results show specifically that we've learned that auditors increase effort after an engagement deficiency is reported in an inspection report, and restatement risk goes down, not just anecdotally, but in a significant way. And there's a spillover effect, of course, a spillover effect within the office, within the firm, within others engaged in the activities of the audit of the client. In contrast, the results suggest disappointingly that when we leave the field without a finding, auditors let up a bit the next year, and they take on more restatement risk. This tells us that audit firms still find it difficult to compete on the basis of quality. They will generally conduct better audits when they perceive that an audit is more likely to be selected for inspection by the PCAOB. Another paper looks at the effects of large firm audit quality control systems. These results provide evidence on the importance of audit quality control systems, particularly audit firm culture and methodology, and the positive influence of remediation on those factors and on audit quality. The Center plans to use the fellowship program to continue to deepen its understanding of audit quality. For those of you in academia, I encourage you to consider a fellowship to encourage colleagues and students who may be interested to apply. We need your thoughts, we need your brainpower, we need your expertise. The Center is also deeply involved in our standard-setting work. The Center leads our post-implementation review program. Economists are currently doing a deep dive to examine the impact of auditing standard number 7 on engagement quality reviews. This is one of a handful of standards that the Sarbanes-Oxley Act required the PCAOB to develop to replace the requirements that firms had used of concurring partners. The PCAOB adopted AS7 in 2007, so we've had this intervening 8 years of experience with it. The economists plan to measure the costs of implementation, assess from an empirical standpoint, whether the standard achieved its intended purposes. Did it produce the conduct that it was supposed to achieve or to produce? We will examine the impact of our oversight. We will flag unanticipated consequences and potential improvements that emerge from the data collected through inspections both before and after adoption. It will have the benefit of public comment from the review that we solicited earlier this year. For example, economists are studying the change in engagement quality review hours around adoption, as well as the changes in the timing of EQR hours around adoption. They're also looking at changes in partner qualifications. We want to know about the concentration of EQR assignments, the rate of partner turnover, statistically significant changes in the quality ratings, the experience, the authority, the workload, the industry specializations of the partners that are assigned to do engagement quality review. Why is that? Because we know that the better an EQR, the better the audit is likely to be. The earlier it's performed, the more likely it is to avoid later workload, later errors. The work will undoubtedly spin off separate research topics in some of those areas for future fellows to pursue, and in turn inform our oversight programs. Center staff are also involved in our standard-setting topics according to the guidance on economic analysis that the PCAOB developed, again with the assistance of Craig and his team at the SEC's DARA in 2014. The guidance set forth 4 major elements, if you haven't seen it, critically focusing on describing the need for a new rule, developing a baseline for measuring the effects of any new rule, and considering reasonable alternatives to the rule, and then analyzing the economic impact of the rule, including both costs and benefits. This kind of thinking is obviously helpful to making sure that regulatory burdens are justified by expected benefits, but I think it does a lot more. Focusing on the need for a new rule and considering reasonable alternatives helps us make sure that we don't rely on unchallenged assumptions or conventional wisdom about the nature of a problem or the best solution. This is particularly useful in the area of audit oversight, where we have so many tools and choices to affect auditor conduct. When we conclude that changing professional practice standards is warranted, economic analysis can assist us in identifying, evaluating, and comparing the advantages and the disadvantages of different standard-setting approaches. A specific new audit performance requirement, an enhancement of some particular area such as independence or skepticism through audit practice alerts or other publications, new disclosures, mandating new disclosures. Within each of those categories, there are specific alternatives. But since the earliest days of the PCAOB, they've tried to use a combination of those approaches, and I think that a lot of these improvements are now on the books. You can look at them, and it would be fair to say the PCAOB has over time adopted a balanced array of standards that thoughtfully take advantage of all these alternatives, and we are elaborating new alternative approaches, staff consultation papers, other means of developing the alternatives, and I think we'll continue to do that. And more recently, late last year, we adopted a transparency rule, a standard that will provide markets and the names of engagement partners, other firms that participated in the audit. Form AP will require the engagement partner to be identified for audits that are performed after January 1 of this year, and the firms, the other participating firms, after audits performed after June 30 of 2017. We're also, and over time, I think that this is going to allow investors to better differentiate auditors on the basis of track records for their quality. We're also nearing completion of a multi-year effort to make the audit report more informative for investors. And this we hope to accomplish by the end of the year. It will be the first major change in the format and the information included in the audit report for perhaps 75 years, and it will include some fairly searching and revelatory information about what the auditors saw in their performance of the audit that should affect the investor's view of the financial statements and what is important to look at in the financial statements. Again, build some confidence. Finally, Center economists are working on a number of other internal and outward-facing initiatives. We are exploring ways to introduce an element of randomization in our inspections. As I mentioned before, there's some evidence the firms are beginning to know when we're coming and what we're looking at. They've always known when we're coming, but I think the predictability of our inspections may be becoming something of an impediment to having the behavioral effect that we expect from our inspections. We're leveraging our research to better predict restatements, which will contribute to our risk assessment program. We're developing some fairly strong evidence about the association between certain aspects of the audit and restatements. The Center will soon hold its third annual economic conference in conjunction with the Journal of Accounting Research. We'll hear presentations of outstanding papers relevant to economics and auditing, selected on a blind read basis, a double-blind submission. This is an important opportunity for our board members and our staff to exchange ideas with top experts on the economic impact of auditing and audit oversight, and to push the research further. Is Nemeth Schroff here today? Nemeth, are you? There you are, yes. Why are you way in the back? Nemeth presented a paper at last year's conference, and based on the discussion there, he and our economic fellow Daniel Obdia of Kellogg co-authored a paper on the perceived assurance value, focusing on the perceived assurance value of the audit report by focusing on our international inspection program as a differentiator. Using the data from 36 countries over the period 2003 to 2013, they found that Pcaob inspected non-U.S. auditors experience a 4 to 6% increase in the market share after our inspection reports are made public. The fact that you are inspected adds some credibility to what you can offer as an auditor. It's an extremely encouraging bit of information on the value of international inspections, both to investors as well as our counterparts, as well as our counterpart regulators in other countries. And a word about that. We've inspected registered firms now in 48 non-United States jurisdictions. In 19 of those jurisdictions, we've conducted our inspections jointly with local regulators, and that's becoming the common practice. The value of joint inspections is that we work side by side with the local regulator. We share ideas, information, techniques. This reduces the burdens on the firms, one inspection instead of 2 or 3, but it also means that both jurisdictions get the information they need to satisfy their own requirements and their own objectives, and it's led to an enhancement, I think, of perception in what the audit has and has not done. Many of our joint inspections are in Europe. I am pleased to say that last month, the European Commission renewed its authorization for member states to work with us in a practical way, to enter into statements of policy, statements of practice and procedure, and to have a joint inspection regime with us. This renewal doubled the length of time of previous authorizations. We had been under a 3-year clock with the European Union. We're now under a 6-year clock, which means that the member states are free to negotiate arrangements and enter into arrangement with us without having to worry about a renewal every 3 years. The question, in other words, is the member state empowered to do this within the union? And the answer is they are, and they will be for 6 years now without question. It's a sign of how well joint inspections have worked and how strong our international network of investor protection has become. In closing, I want to go back to where we started. If you start with the abstract idea that audits are merely mandatory costs of issuing securities, you end up with the judgment that you make sense to keep them as inexpensive as possible. But the point of the audit is the same today as it was in 1933. It's to give investors the confidence they need to commit capital, provide assurance that investors can rely on the financial statements, provide investors the basic assurance that someone has checked the company and has determined that it is not a fraud like Mckesson Equity Funding, Lincoln Savings and Loan. And my own commitment, my own belief that not only audit oversight by an independent body such as the Pcaob, but the amplification of the skill base of the Pcaob by independent research and analysis from persons like yourself is fundamental, and that we and our counterpart regulators around the world, along with the audit profession, will be improved and much benefited by a continuation of that. Thank you, and I look forward to fielding any questions or comments or thoughts. Some of this I realize is controversial. I thought some of it was controversial. Savannah.
So you talked a little bit about the recent memorandum with the EU on inspections. And one of your former staffers has an article on interpreting that. Oh, I'm sorry.
Yeah.
You talked about the memorandum that was renewed with the EU on inspections, and one of your former staffers, who's now in with a law firm, I believe, or some other firm, interpreted that as meaning that it looks like the likelihood of joint inspections will be decreasing. In other words, that it's setting the stage for the EU to be asking the Pcaob to rely on the EU's home country inspectors. I don't know if you saw that article, but the article also said that...
Of course I saw it.
Okay, good. And that would be noticed by the Chinese in terms of negotiating in joint inspections there. So I just wanted to ask if you would clarify that issue.
Yes, I think clarity is in order. Without engaging in a debate with our distinguished former colleague. We avoid, we don't, at the Pcaob, we don't talk about people going over the dark side. Sometimes people talk about this in the Division of Enforcement at the SEC. We don't. But no, he's a member of a very fine law firm, and he was eminently involved in the Office of International Affairs. But to clarify, and without engaging in a debate, I was careful to say, you have to remember that we were for a long time invited to conduct joint inspections with the UK. Couldn't do it. Why? European Union said you had to have an adequacy determination. We didn't have one. The adequacy determination had to find that you had a regime that was at least the functional equivalent in terms of excellence of the European regime. They hadn't done that. They did that in 2013. So between 2004 and 2013, we had begun inspections with the UK, had to discontinue it, had begun inspections, and we're continuing to inspect with Japan and other countries. Had begun with Germany, had to discontinue. 2013, the EU says, okay, we've made the adequacy determination. They are functionally up to our standards in Europe. And so at that point, we began to enter into the statements of protocol, the SOPs, the memorandums of understandings we now have. So what this means is that the EU is saying we have the authority, of course, with respect to European members, to determine whether the member state can enter into a statement of protocol with the Pcaob, permit inspections here in Europe. That still exists, but it exists now subsequent to a 6-year determination that the member states are free to do this. Each member state has its own privacy and data protection laws. So in every state we enter into, we are concerned about and have to work around and work with authorities there to be sure that, that data protection and privacy laws are observed. But it means we can now do it. The only states now, as I think our published reports show, that are not members of this regime of joint inspections have been until recently Ireland, Italy, Portugal, Greece. We have Greece and Belgium. We have just agreed with Greece. We are going to be, I think, finishing our arrangements with Ireland and Portugal. Data protection, again, has to be complied with. So Belgium, difficult case. I mean, you all read about some of the problems that obtain in Belgium. Each of these countries, in each of these countries, the civil service and the administrators that we deal with, or the independent agencies we deal with, are part of a political system, as are we. They have to be concerned in that political system that in fact they are not simply handing over the inspection of firms in their jurisdiction to another country, and we're very sensitive to that. The expansion of this regime, the fact that we have expanded it to over 40 countries now, I think is a testament to the skill of our staff and the tact and the savoir-faire with which the inspections have been conducted in those countries. You have very different levels of competence in countries, depending on how long they've had a regulator, how much they have by way of public audits. Each country is aware of this. There is a great potential for us to aid and enhance the capacity of that regulator to avoid missing something, not having access. That also is enhanced by this regime. We have invited them over here. We have actually, just as we are escorted into the firms and conduct an inspection of a German audit, a German auditor and a German audit. We've brought the Germans here, and we have brought the English here, and we will bring other countries' regulators here. So we have the ability to simplify and make more efficient their inspection regime as well, and we do it. Suffice it to say, it does not surprise me that the Europeans don't want to give us unlimited, unending access to come in and inspect. They may have changes in their regime. I also think that it's quite reasonable for them to expect that we will begin to recognize where our system of audit inspection can be made more efficient and less costly by picking up and relying on work they do. And that happens. That happens. Might not surprise you to know that with the Canadians, we do rely on some aspects of their inspection of firms. Why shouldn't we? So this is going to be an ongoing story, but it's I think a very healthy story in terms of the evolution of an international system and a regime that can actually break down barriers. Yes?
During the last 15 years, I've taught a program on audit committees and for audit committee members. And one of the persistent feedbacks or concerns that the directors raise is that they feel that there's relatively little choice they have in terms of audit firms that they choose to conduct their audit. That means that there's little market competition in the audit industry and perhaps less innovation than one might hope if there were more market-driven forces. I'm curious as to how you react to that, and if you think it's an issue, how it might be addressed.
We're concerned about it. We believe the concentration in the industry and the black box that an audit can represent, and at past times has represented to audit committees, is a deterrent. It's a deterrent on better audits, better audit quality. Our transparency release is intended to address that. If we can make it more apparent what the records of the, not merely of the engagement partner, but of the firms that have participated in a global audit, what kind of firms those are, how well regulated they are. We think that adds to some of the factors that people will want to assess. We had an audit quality indicator concept release that went out. We had a lot of discussion about it. That tends to talk about what audit committees may want to consider when they're talking to an audit firm and making their choice of auditors. The reaction is fairly strong that we should not promulgate a set of 20 or 10 or 8 audit quality indicators that are key. Singapore has 8. So people are doing this. People are promulgating audit quality indicator lists that they feel are definitive or that they feel are significantly clear that audit committees can and should apply them. It's also been made clear that nobody thinks that we should require a firm to have audit quality indicators, that we certainly shouldn't require a firm that has them to disclose them to an audit committee, let alone the public. So this is a case in which the emerging information base that people are considering as relevant to differentiate audit firms, this is where your question goes, is also in a situation of some flux and some development. And I think we will see the market work on that phenomenon, and we will see how far the market gets. The profession, going back to my little sermonette on the profession just creeping up on and holding back from taking the step that it needs to take at different points in enlivening the auditor to the actual duty of fraud. The leaders in the industry now, the people whom I see as being thought leaders and who are going to be the next generation of leaders of the firms, I think see that with more risk and with more openness to what the public needs to know and what the audit committee needs to know about how they do it and why they do it, there also comes success. There comes a future for young auditors and for the firm. So it seems to me that we will see more market forces opening up what has traditionally been a very tight system. The Public Oversight Board failed because the firms wouldn't fund it and because any of the quality reviews they did of each other were simply clean, with no questions asked. We're on the other side of the world from that now. Audit has changed significantly. Yes.
This kind of continues with that theme of quality, but my question extends over to Europe. So when you think about audit rotation, what's the plan to evaluate over time the increase or decrease in quality as a result to audit rotation in Europe versus the United States? I'd like to get your thoughts there. I'm not going to ask you whether you agree or not, because that's too controversial, but what's the plan to evaluate whether quality increases?
Well, first, I'm fascinated because when I started here, the Europeans were considering whether to give us an adequacy determination. This was 2011, adequacy determination 2013. The European Commissioner was a very forceful commissioner named Michel Barnier, who is now the negotiator for Brexit. And Commissioner Barnier had a plan, and he was going to have mandatory firm rotation. It seemed to me that it would be a good idea for the Pcaob to express some interest in finding out what was going on with mandatory audit firm rotation. So we issued a concept release. We said, what do you think about it? Well, there was a firestorm. Many people thought it was absolutely necessary and that we should do it sooner rather than later. There was an equally strong body of opinion that it would kill the auditing profession, that audit fees would spike by 20%. The GAO had done a study that was rather inconclusive about this, and they had also kind of said, well, it could send audit fees up by 20%. Of course, audit fees went down by 20%. And we concluded at that point that we were going to have to watch carefully to see what the effect was on this regime, because Commissioner Barnier had made it very clear his interest in establishing a mandatory firm rotation regime in Europe was directly related not just to audit quality but to competitiveness. He was concerned about the fact that that they wanted to eliminate, as they did by law in certain ways, the dominance of the big four firms and the global network firms. So this has been going on now. We hear a lot about it from the firms that are there. I think it has been a challenge, a real challenge for the firms. Audit fees have not kicked up. A lot of the preconceptions we had about it may be untrue. What's the effect on audit quality? That's what we have to concern ourselves with. And that's why we have a Center for Economic Analysis. That's why we want people to start studying these problems and thinking about them in a systematic way. Because the one thing that we learned out of the experience, I think, with the concept release in 2011, the firms ran in, Congress enacted a statute, they enacted a bill in the House that would prohibit us from going forward with mandatory firm rotation. It sits there today. But the one thing we learned from that exercise was that people don't know what the effect long-term of a mandatory audit rotation regime would be on audit quality, and people don't know what the best result, what kind of regime would best induce to audit quality versus be corrosive. We know, for example, that an entity, a business that rotates its audit firm every 2 or 3 years, is probably not getting the highest audit quality, and we have to worry about that. So this is a continuum of conduct. It is a continuum of complex conduct, and much remains to be known about it. It's a burning, it is along with some other questions, it is the burning issue that we're going to be facing as a society with only 4 major audit firms and some other firms that they're not going to achieve the critical mass of the Big Four anytime soon. Yes, sir.
So I'm having a little trouble understanding how the inspection regime will actually facilitate the capturing of some of these frauds. If I can give you an anecdote as a way of maybe helping me understand it, is that if we go back to what Luigi and Daniel were debating last night about the mortgage crisis, if the audit firms had followed very common procedures and relied on something like the rating agencies, how would the inspections, and assume they had done it in, to the letter or of the form rather than the substance of what was underneath it? It's not clear to me how the inspection process, and I've heard it's much more about form than substance, would actually ferret those kinds of things out, because it's a very different kind of change that would require to be done in the audit for that. It's not about the financial reporting, because you're relying on an expert who's done the models, and et cetera, et cetera.
Well, the inspection regime can prod auditors to do a more careful job, and we know that it does do that. We're beginning to get the evidence on that. It can also challenge the audit team, and it can challenge the firm to start broadening the scope and the scoping and the execution of the audit. We find cases in which auditors have scoped in a fraud risk, and then they don't follow it up. Now, the fact that we're going to come look at that, and if we find it, we're going to call it out, that has some prophylactic effect. And we know it does on the office, the engagement partner, the engagement team, the office. It has an effect. And so it's a limited tool. It's a limited tool. Your broader question is, how would auditors have known, goes to the question that The Big Short raises. Why didn't they look? In other words, it's not as if the evidence was not coming in. Going concern issues, critical audit matter issues, the issues that are raised by an expanded audit reporting model in Britain, all of these have the potential for forcing the discussion earlier to the audit committee and forcing the recognition of trouble and of a change in the business practice. We don't have a regime in which auditors comment on the appropriateness of the business model. We're not nearly there. But that's, in my mind, what comes out of the financial crisis, is that auditors were willing to go along with, as they did with Enron, with transactions that were not substantial transactions, true sale opinions that were not well-founded. The system can get you there. It usually gets us there late. I'm out of time. Thank you.
So
Thank you all.
I would like to thank you.